What if a company takes a major decision but never tells the regulator? No record, no transparency. That's where Section 117 steps in. Welcome to Corporate and Securities Law Compass. Today, we decode a critical compliance requirement, Section 117, Resolutions and Agreements to be filed. Let's break it into provision, explanation, practical examples. Under Section 117 of the Companies Act 2013, mandatory filing requirement. Company must file certain resolutions, agreements, explanatory statement if applicable, time limit within 30 days. Form filed in Form MGT-14 special case. If articles are altered, must be updated in articles or attached to copies issued. Penalties for default. Company 10,000 rupees plus 100 rupees per day, maximum 2 lakhs rupees. Officer 10,000 rupees plus 100 rupees per day, max 50,000 rupees. Serious. Penalties for default. Company 10,000 rupees plus 100 rupees per day, maximum 2 million rupees. Officer 10,000 rupees plus 100 rupees per day, maximum 50,000 rupees. Serious. Resolutions covered. Special resolutions, unanimous resolutions, MD appointment, class resolutions, winding up decisions, certain board resolutions. Now let's simplify. What is Section 117 about? Filing important decisions with registrar. Why is it required? Ensures transparency, creates public record. What gets filed? Only important resolutions, not routine decisions. Role of MGT-14, official filing form, includes resolution copy, explanatory statement. Impact of delay, daily penalty. Even small delay is costly. Governance impact, prevents hidden decisions, ensures accountability. Example 1. Mr. Prasad Khopkar. Company passes special resolution, files within 30 days, fully compliant. Example 2. Delay case, filed after 45 days, penalty applies. Example 3. MD appointment. Company appoints managing director, filing required. Example 4. Winding up. Company decides liquidation, must file with registrar. Example 5. Articles change. Articles amended, updated version required. Example 6. Non-compliance. Company does not file, heavy penalty imposed. Example 7. Class resolution. Preference shareholders decide, filing required. Final summary. Section 117 ensures public disclosure of key decisions, timely compliance, transparency in governance, accountability of management. If it's important enough to decide, it's important enough to disclose. For more powerful corporate law breakdowns, like, share, subscribe. This is Corporate and Securities Law Compass. See you in the next concept. Disclaimer. Viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The Speaker, the Institute of Company Secretaries of India, and any organization or listed company with which the Speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The Speaker confirms that no unpublished price-sensitive information (UPSI), confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.